Good afternoon, everybody. We'll get started here in just about another minute. There's a bunch of people joining the broadcast as we speak, and I'm just going to give them about another 60 seconds to get situated, and we will go ahead and get started. Okay, here we go. Well, thank you everyone for joining us for this week's Landman Education Series. We always enjoy putting these on, and we've been getting a lot of great attendance this year on our webinars. So to those of you joining us for the first time, welcome. And for those of you coming back for more, you must be gluttons for punishment, but we really appreciate your continued support. And it is for you that we continue to do these and hope that you get something valuable out of each and every one of them. Today, we're going to be talking about federal leasing. As many of you are aware, federal leasing has come under fire in the last year, particularly under the current administration. And I will start off today giving a quick update on where we stand in the legislation and litigation regarding the federal lease ban. And from there, I'm going to jump in and talk a little bit about some of the basics of federal leasing, federal oil and gas properties, and this presentation is not state specific. I will touch on some differences here and there in some different states, but the interesting thing about federal leasing is the regs, most of the regs anyway, are intended to apply across pretty much any jurisdiction where federal lands are located and federal minerals. And obviously, depending on what state you're operating in, you're going to be dealing with a different BLM office and various field offices. My name is Brad Gibbs. I'm a partner at Kiefaber and Oliva. I've been with the firm going on almost 10 years now. I'm board certified in oil, gas, and mineral law in Texas, and my practice is focused on pretty much all things upstream oil and gas transactional related, due diligence, title, pooling issues, various contracts. I'm also involved in a number of litigation matters that are oil and gas centric that our firm handles, and pretty much any other general upstream matter is within our capability to handle. So I'm here in our Houston office. We also have an office in Columbus, Ohio. We've got about 22 attorneys at the moment, and we are definitely growing and staying very busy. We've seen a lot of good things happening this year with prices on oil and gas trending the direction they are. We expect to stay busy moving into next year, and I hope that's the same for many of you. I personally am licensed in Texas, North Dakota, Kansas, and Wyoming. I also help on a substantial amount of work in New Mexico and Louisiana, and obviously in quite a few of these states we encounter federal lands. So as I mentioned, before I jump into the substantive bulk of the presentation today, I would first like to touch on President Biden's attempts to pause federal leasing and permitting practices and sort of touch on where we stand as of today and what things look like moving forward. So back in January of this year, in an effort to slow our contribution to climate change, President Biden signed Executive Order 14008. I'd like to pause here to mention that my graphic is not intended to be a political statement at all. I just thought it was kind of hilarious that somebody had made this. Joe Biden as the crypt keeper and thought it was appropriate for a Halloween presentation, but I mean to offend no one beyond that. So just a small disclaimer. The order 14008 ordered the Department of the Interior to pause new oil and gas leasing on public land and offshore water, quote unquote, to the extent possible, and to review existing leasing and permitting practices related to fossil fuel development on those properties. So, you know, you often hear about the federal lease ban. I mean, there technically has not been a federal lease ban. What the administration has essentially done is paused federal and gas leasing pending further assessment to decide sort of what their move is going to be. And that is the limbo that we've been in and somewhat remain stuck in. The pause resulted in the postponing of two high-profile leases in lease sale 257. Two high-profile lease sales, being sales 257 and 258. They had been approved and scheduled under the 2017 to 2022 5-year oil and gas leasing program under the Outer Continental Shelf Lands Act. Obviously, in the last year, offshore leasing and development has come under renewed scrutiny in light of a couple of spills and environmental issues that have come up. So lease sale 257 is areas in the Gulf of New Mexico, and lease sale 258 is in the Cook Inlet in Alaska. In March of this year, 13 states filed suit arguing that the executive order violated the OCSLA and the Mineral Leasing Act, along with other claims. Those are the statutes that prioritize oil and gas leasing development and require the secretary to hold lease sales in the Outer Continental Shelf. In June of 2021, the United States District Court for the Western District of Louisiana granted the plaintiff states a preliminary injunction. This had the effect of temporarily lifting the pause and resuming the leasing of public lands and offshore waters. In the court's written opinion, it suggests that the Biden administration does not have the legal authority to issue a blanket pause. In addition, the new policy likely did not follow federal procedures for changing government regulations. So, you know, they were really looking for some legal and regulatory loopholes to allow oil and gas leasing and permitting to resume while the Biden administration was sort of looking over what its next move was going to be. In August of 2021, federal defendants filed a notice of their appeal of a Louisiana federal district courts of the Louisiana Federal Court District's decision granting the plaintiff state's motion for preliminary injunction and barring the administration from implementing the pause. So this was appealed by the federal government. And a week earlier, the plaintiff states had filed a motion for an order to show cause and to compel compliance with the preliminary injunction, arguing that the federal defendants violated the court's order by, despite the injunction, refusing to hold new onshore lease sales and move forward. However, the federal government basically said they were going to proceed with at least the sales in question, and the plaintiff states withdrew this motion. It appears for now that there are going to be some federal lease sales and permitting that's going to take place, at least on a limited basis. I believe that most of the local BLM offices are beginning to resume these activities, and the Department of Interior has stated, however, that they will continue to pursue quote unquote deep changes. They haven't really gone into much detail on what these deep changes are going to be, and the future therefore remains somewhat uncertain, though certainly the future is, I think, bright at this point for next year, you know, with or without federal oil and gas leasing for onshore activity. So now I'm going to jump into the bulk of my presentation. I hope to get through everything today. It's, you know, there's a lot of information that I would consider sort of the fundamentals of federal oil and gas leasing and operations and transfers of interest, things of that nature. You know, and if I get a little bit clipped at the end and start to run over time, you know, you will get a copy of these slides. Hopefully the slides are fairly self-explanatory. So again, hopefully I get through all the lease segregation and communitization stuff, but if I don't, you will get that information. I do, you know, certainly encourage you to look over it. It's not only, I think, interesting, particularly if you are operating on any federal leases, but it's just sort of good general background information to know in the federal context. So recording and constructive notice. If there was a single thing that was an issue that recurs over and over in federal oil and gas titles, it revolves around the recording and constructive notice aspect of you know, federal leasing and transfers of interest. A lot of people don't understand why this is important. They ignore it, and they run into issues, particularly if they are looking to get square with the BLM, or potentially they are looking to divest the interest and they've just kind of ignored this dual recording requirement. So the bottom line is that you must search and file in both the county and federal records. This is more or less non-negotiable. If you try to do one or the other, you're going to get a title opinion back that basically makes this a requirement and says, you know, we can't really confirm your title without looking at both. And that is for reasons that I will go through on the next few slides. So first of all, most of this is going to be review. Some of you may not be very aware of federal operations. So I'm going to start with a few basics. So first of all, let's talk about who the Bureau of Land Management is. The federal lease records are maintained by the Bureau of Land Management, which is a section of the United States Department of the Interior in Washington, D.C. In theory, at least, the full records are intended to be filed in Washington, D.C., and partial sets of duplicate records are maintained in the BLM state offices. Common practice is to search the state office records only, though the BLM takes no responsibility for incomplete records in the state offices. Some might argue, and there is the possibility that the state offices in many instances may actually be more complete than the DC records. At any rate, I don't know of any operators, maybe you do, but I personally have never encountered an operator that actually goes and searches the DC records. It's usually the state office records. For example, the BLM office in Santa Fe in New Mexico or in Billings, Montana. The Legacy Reho system, LR2000, you know it, you love it. It's a searchable database. You can't pull any documents off it. It's sometimes not all that intuitive. There is some information you can sometimes gather off it, regarding plats, things like that, but it can be somewhat difficult to navigate. And at any rate, an in-office examination is basically going to be necessary. The BLM, will provide the lease file for a lease. However, they're going to essentially just take whatever their PDF file is, attach it to an email and send it to you. There's no guarantee that they've actually picked up everything relevant, nor do they go through and verify that or certify it. A federal abstract company is best. Depending on what state you're in, there may be some excellent federal abstract companies available. For example, New Mexico has several great options. In other areas, it may be less normal for a broker or an abstract company to focus mostly on the title records, and maybe your local broker will certify it to some extent, or they may just end up requesting the lease files from the BLM the exact way you would have, and you may get what amounts to an uncertified abstract. The good news is usually you can rely more or less on an uncertified abstract from the BLM, but again, you run the risk of something potentially missing from that. And here's just the applicable regs in case any of you really want to put yourself to sleep and go read those. And you want to be aware that the Mineral Leasing Act of 1920, although it's been amended numerous times throughout the years, this is still the governing act that basically is the framework for all oil and gas leasing and provides sort of the regulatory background that we'll be talking about today. Records regarding operations, well completions, production, communitization, things of that nature are generally going to be in the BLM field offices and not in the state offices. So to the extent you're looking for sundry reports, things like that, unit agreements, you're often going to get told by the state land office that you need to go talk to the field offices about that. And many times the federal abstract companies will actually accept these types of agreements out of their abstracts, and they will say, look, we've performed a search of the state office, but we haven't necessarily included any operating agreements, unitization agreements, communitization agreements, things of that nature, though those are available for those of you that seek them. So the county clerk, We all know everything there is to know about the county clerk, but obviously county records are maintained by the clerk in the county where the property is located. And certain instruments are also filed in the records of the district clerk, probate clerk, and in the tax records if any portion is patented fee lands. So, just that's sort of the backdrop for the other set of records that you're going to need to search. So if we're talking about federal leases, why on earth do we care what's in the county? Well, here's the thing. It goes to this idea of bona fide purchasers and notice. There is no federal statute in any state that applies to any state or in the federal regs or anywhere else, providing that the BLM records, either in Washington, D.C. or in the state offices, are actual or constructive notice to persons acquiring interest in federal oil and gas leases. So you can be knocked out by a bona fide purchaser without notice if you have only filed in the BLM records and somebody comes along and searches the state records and says, well, we don't have any transfer to your company. We bought it from the company that you're purporting transferred it to you. We're a bona fide purchaser. We win in title. So clearly the county records are important. And the other thing that you have to be aware of is that there's a lot of instruments that are not filed with the BLM regularly or are not even accepted by the BLM, liens, easements, etc. You sometimes see some of these things pop up in the BLM records because, maybe one day they were overstaffed and they kind of rubber stamped something as received and threw it in the file. Generally speaking, though, most of this is not going to be recorded with the BLM. So you want to be aware of, liens and other encumbrances, production payments, sometimes different types of overrides, and more importantly, various provisions that, may not be able to be shoehorned into the federal filing forms that are going to be described in much more detail in these county conveyances. So then why do we want to search and file in the federal records? Well, great question. If there's no notice in the federal records, why does it matter? Well, the regs say you have to. Each transfer of record title or of operating rights shall be filed with the proper BLM office on a current form approved by the director or exact reproductions on the front and back of such form. The rights of any such assignee shall not be recognized by the BLM until such assignment has been approved. So basically, as far as the BLM is concerned, they don't care what you own in the county records. They only care what you own as to their records. They're going to adjudicate your title for most conveyances. And, depending on whether you're the transferor or the transferee, if you don't file these things, you may have lingering liability for a deadbeat operator, among other liabilities as far as the BLM and the Office of Natural Resource Revenue is concerned. So then what needs to be recorded in the BLM records? And, this is not to say they shouldn't be recorded in the county too, because they absolutely should. But the BLM is going to want to see assignments of record title interest. They're going to want to see transfers of operating rights, which they also refer to as subleases. And I will describe the difference between these two types of interest in some subsequent slides. Overriding royalty assignments. Really they should be filed with the BLM to protect your interest, if nothing else, if you're an overriding royalty interest owner. This doesn't always happen. It's not, some might say it's not strictly necessary. It is best practice to file your overriding royalties, but be aware that they are essentially rubber stamped and thrown in the file. They are not adjudicated in any way, shape, or form by the BLM. But they're good to have in there for a complete record of title. Mass transfers, these are just transfers of record title or operating rights that affect a number of leases. Corporate name changes and mergers, probate materials, and divorce decrees. And I apologize that the part next to divorce decrees is actually supposed to be next to probate materials. And that's when you're talking about probate materials, one interesting thing that you encounter is that every state you're operating in has slightly different requirements for what will pass title from an estate in the state. The federal regs have to sort of create a blanket regulation of what they want to see in order to pass the title in their records. What the BLM is going to want to see at a minimum is a will or the decree of distribution. You know, for example, in North Dakota, to transfer title in the county records, you're going to need an actual deed of distribution from the personal representative of an estate after proper probate has been conducted. New Mexico, similarly, you're going to want to see a deed of distribution that's been filed. You know, check with your local BLM office as to what they're willing to accept, but per the regs, they're going to want to see the will, if there is a will, or the decree of distribution, if you're talking about an intestacy type situation, and a qualification statement, and I will discuss that a little bit more on a subsequent slide as well. So examining federal titles and common title defects. I'm going to run through some of the big ones that we see, here's just a depiction of sort of what some of the starting points of a federal title examination. It's the historical index that kind of tells you what's been filed against what lands in a section. And then you've got the master title plat. And this basically shows you, you know, where the federal interests lie and kind of who owns what. So step one, the plat books. Fortunately, they are not quite as difficult to decipher and navigate as H.P. Lovecraft's Necronomicon, though some might say that they are just as intimidating. However, once you kind of get the idea of how they're organized, it's really not that bad. And again, this is going to be the starting point of your federal title examination. They're organized by township and range. They contain the actual plats, historical indexes, conflict sheets detailing disputes between claimants, master title plat, oil and gas plat. So you'll see your surface patents, your various rights of way, what leases have been issued. Also look to the historical index, serial registers, patent surveys, survey plats, unpatented mining claims. These are all different indexes, and this is why it's important to go and actually perform an examination of the federal records by an abstracting company. Next step is going to be determine the proper act that you're leasing under or that your historic lease was issued under. Most are going to be under some form of the Mineral Leasing Act of 1920. We occasionally encounter some federal leases that predate the Mineral Leasing Act of 1920 and are still held by production. There is some very, very old production particularly in New Mexico, that you will encounter that have been held by some, very old secondary or tertiary recovery units, often shallow production that's holding these very, very old leases. And you can run into all kinds of issues just by, due to the fact that there was a point in time where a lot of the deeper formations were not being targeted. A lot of strange and conflicting depth severances sometimes happen early in the title, sort of based on what depths were producing in these shallower units. And anybody who's worked New Mexico for any length of time has encountered all of these fun complexities. So the Act provides for non-competitive leases as to lands not within what's called a known geologic structure, and competitive leases for lands that are within a known geologic structure. In a right-of-way, if you encounter a right-of-way that predates your lease particularly, then it may be that your only option to lease that right-of-way is under the Right-of-Way Leasing Act. I'm going to go into some detail on that because that's kind of an arcane area of federal and gas leasing that a lot of people don't know about. Of course, if you're on tribal lands, you're going to be dealing along with the BLM, also with the Bureau of Indian Affairs, the BIA. Case file for active leases. There's a case file for every lease. If a lease has been segregated, there will be a separate case file on the segregated portion and the base portion. So just be aware of lease segregations. I'll talk a little bit about how they happen, and you may end up, if there's been a segregation, you may end up in a position that you're having to run title on numerous federal leases as one has been given a new serial number. So Common title defects. I didn't really mean for this to implicate a birth defect, though I see now that that may be the way this is taken, but I guess that works too. By the way, this is from the show American Horror Story that had a couple of great seasons and kind of went downhill, but still some fun Halloween viewing. So dual recording is the #1 title defect that you will see on federal lands. It's going to be in almost every title opinion because something somewhere was not recorded in both places. It's just a given, and it's just the way it is. You know, depending on when it happened and the circumstances, there are different ways to cure it or waive it, but it's going to come up, and it's just amazing how often things do not get filed in both places where they should be. The problem is you end up with parallel chains of title that conflict with each other. And you know, some leases may not, some lessees may not be filing with the BLM because there's a qualification issue or they want to avoid a lease segregation. You know, not a good excuse, but they do it anyway. You know, sometimes there are certain types of interests like NPIs, production payments. They aren't easily put into the federal form. I will show you the federal form. It's very simplistic. And, you know, oftentimes things like NPIs have a lot of provisions, qualifications, calculations that are attached, and you just can't fit it physically on the federal form, so they just get omitted. Sometimes different assignments get filed in the county and with the BLM, kind of for the same reason, because there may be provisions in there that the BLM is not really equipped to handle, that the BLM does not adjudicate, or even that the BLM will, you know, often reject, like wellbore severances. And so you're going to see sometimes different forms of assignments in the county. Rights of way, another common title defect. 17.5% clause. I left this in there because, you know, about once or twice a year, we get a question about this from one of our clients, and they just want us to explain what it means and, you know, who it binds. And these 17.5% clauses came from an older reg that used to provide that an agreement creating overrides, when added to the previous overrides on the lease royalty, aggregating in excess of 17.5% is not permitted unless the agreement expressly provides the excess royalty is suspended when the well, you know, becomes a marginal producer, stripper well. So it basically says, you know, the BLM wants to make sure that it's economic to operate stripper wells. They sort of passed this to encourage that and to avoid leases getting overburdened to the point that an operator may decide that it's no longer economic because the revenue just isn't there. So this, you know, you will see this in some older leases, but it was deleted in 1988. It no longer applies, essentially. The reason it's going to be aware of it is because what will happen, again, because of this dual recording requirement, is you'll sometimes see leases in the county, assignments that have been recorded in the county that refer to or incorporate by reference these types of provisions, like, hey, we're assigning you this override, but if our production ever drops below 15 barrels, your override is suspended. And the thing is, as between the parties, even though the reg has been dropped, but as between the parties, this may still be applicable. You know, your override, it's possible that it could be suspended if the well drops down to a marginal producer. Not something I see that often, have encountered it, and just something to be aware of. And, you know, usually we'll just say, hey, you know, this may not be in the spirit of the agreement. You know, you guys stipulate as to whether this is, you know, intended to apply or not. And, you know, we've had limited success getting people to actually follow that advice, but at least we put it out there. So here's the assignment of record title and the assignment of operating rights. You will see that they are very similar. They are also very much a kind of grid where you plug in just the most basic information. In a lot of ways, when people get them right, they're great because it's very clear what you think you owe, what you convey, and what you retain, and, you know, overrides. By the way, overrides can be assigned on either form, and it generally will depend on whether record title and operating rights have been severed. Another common issue we see is, operators not exactly understanding when to use one form or the other, and occasionally they end up in a situation where they're meaning to assign one but not the other, or they're meaning to assign both but they effectively only transfer one. So hopefully I will be able to shed some light on that over the next couple of slides. When we're talking about record title, this is not title in the county, though that is also sometimes confusingly referred to as record title. This is something that is basically unique to federal leasing. Some states have kind of adopted this sort of regime too. New Mexico, for example, recognizes this same type of distinction on state lands and state leases. But record title under the federal regs is the primary ownership of an interest in an oil and gas lease. This includes the obligation to pay rentals, the rights to assign and relinquish the lease. At the end of the day, if you own record title, you are sort of the primary responsible party for making sure that the lease is properly administered, making sure that royalties are being paid. The BLM may look to you first if a party is in default, and you may have some liability. So, again, if you're intending to step away completely, divest yourself fully of a federal lease and you own record title, you want to make sure you get that picked up as well, as far as the BLM is concerned. Record title can't be transferred as to death. You can't have a death severance as to record title. You can't convey anything smaller than a 40-acre legal subdivision. You can't sever oil from gas. BLM approval is required. They will get this, they will adjudicate it, and they'll either accept or reject it. Operating rights is working interest. So it's the exact same concept as general working interest on fee lands, and it is the interest or contractual obligation created out of the lease, authorizing the holder of that right to enter the leased land and conduct operations. Operating rights may not be transferred. Operating rights may or may not also be transferred through an operating agreement, which creates sort of a third bucket of rights that you can think of as contractual working interest. And both contractual working interest and operating rights can be limited as to certain horizons or zones. Another issue that's common, and again, I go back to New Mexico just because I see it there all the time, is you end up with 3 separate chains of title. You've got to track what's happening with the record title, what's happening with the operating rights, and then what's happening with the contractual working interest if there's a JOA, because it may be very different. It may be very different at different depths. And you have to really be aware of who owns what and the source of their interest and what the subsequent assignments of that interest are really doing. And it certainly can get far more complex when you do have an operating agreement, and you may have parties coming in under the operating agreement that don't even own an underlying operating rights or record title interest in the lease. Operating rights, BLM adjudication and approval is also required. So assignments of record title, when the operating rights are not severed, so this is when you own, let's just say you own 100% of the interest. You're the actual primary lessee of the lease. If that's the case, a record title assignment will convey both operating rights and record title interest. Essentially, if you own the same percentage of record title and operating rights at any depth, then an assignment of record title is going to carry both with it, and you don't need to file separately. So it's not necessary to file both a record title assignment and an operating rights transfer. If the operating rights have been severed, in other words, if you've kept record title and conveyed operating rights away as to a portion or as to certain depths, then you're going to only be able to transfer that interest subsequently with an operating rights transfer. When we're talking about partial assignments of record title, this is a situation where an assignor conveys 100% of the record title and a portion of the lands in the lease. So again, can't be less than 40 acres, but if a federal lease covers the south half of a section and you're conveying away 100% record title in the southeast quarter, that is automatically going to be a segregation event. And that partial assignment, as it's called, is going to segregate your lease into two separate leases. It'll be a base lease and a new lease. And the segregated lease will get its own new serial number. Typically, the base lease is going to keep the original serial number, and the segregated portion will get a new serial number. It'll be given a new lease file and create an entirely new chain of title. Releases and this 100% transfer of record title will release and discharge the assignor from all obligations thereafter accruing with respect to the segregated portion. Assignments of operating rights, you got to identify the lease formation depths, either by zone formation or deposit. So you got to have, basically a description that meets the statute of frauds. It's not necessary to file separate operating rights transfers when conveying an interest in several sections of land if they're all covered by a single lease. One transfer can convey various interest percentages at various depths. You just have to list them out. Again, you can shoehorn these into the federal forms, and it's commonly done. Overriding royalties. As I said earlier, you can file transfers of overrides on either form. It's usually going to depend on sort of what you own and what type of interest you own. Only one originally executed copy is required. Transfers of record title and operating rights, you got to file three original copies. Only one with overrides. BLM approval is not required. They don't adjudicate it. They throw it in the file. This also applies to production payments. Mass transfers, this is just a transfer of a bunch of different leases. You've got to, you basically file your form with an exhibit attached that will list all of your leases. And the BLM generally says we like this to be done only if it's 10 leases or more. Each assignment is going to be adjudicated and approved individually. So one of the big things is it may slow your process down considerably if you're filing a bunch of leases together because they're going to go through and adjudicate every single one of them before they approve the entire mass transfer. Entity name changes and mergers. To be recognized by the BLM, there's a list of things you have to submit, serial number of your leases, that'll be listed in there. Any pending assignments and agreements. You're basically gonna have to show the certificate of name change or merger, any amendments of articles of incorporation. So, the same kind of stuff that you'd file in the county to show that there's been a name change or a merger. If one company buys out the interests of another company and it's not a merger, then you're gonna have to file an assignment. So that's probably pretty self-explanatory. I alluded earlier to these qualification statements. Leases or interests can only be acquired by U.S. citizens, and you have to file a statement basically that averes to all this, kind of an affidavit. And record title can't be held by minors. There are situations where the legal guardians or trustees of minors can hold record title, but the minors themselves can't. There is a acreage limitation of 246,080 acres in the regs that you can own in any one state. And an individual with more than 10% stock is charged with a proportionate share of the corporation's leased interest. So this is to kind of keep foreign companies, entities, individuals from getting too great of control over federal oil and gas resources, or one individual from having too much control in any given state. This is sort of an energy independence policy, and so that's why that exists. So federal right-of-way leasing. There is a thing known as the Right-of-Way Leasing Act of May 1st, 1930. So the reason this exists is that certain federal rights-of-way can only be leased under the Right-of-Way Leasing Act if the right-of-way actually predates your lease. So in many instances, you may not realize your lease doesn't cover prior existing rights-of-way. And this is because depending on the type of right-of-way that was granted and when it was granted, the right-of-way may have granted a limited fee And this is what, basically the BLM has said in various opinions over the years, subject to ownership reverting back to the United States. So the United States may have basically given somebody a fee interest. Sometimes the lease may exclude these prior existing rights of way. Other times you may not even know they're there. Then in 1983, the act was amended to apparently limit this 1930 act to some extent. So now, in light of this 1983 act, the 1930 act apparently only applies with respect to railroad right-of-ways under the Act of March 3rd, 1875. So again, this is pretty specific. And reservoir irrigation easements issued under an 1891 act. You will also sometimes encounter this on potash deposit lands. And despite the broad language in the 1930 Act, the BLM only issues right-of-way leases for railroad and reservoir easements. I've never seen one outside of this context. So even though the 1930 Act says other rights of way acquired under any law of the United States, whether the same be a base fee or mere easement, the 1983 Act, it didn't overturn the 1930 Act, but this is sort of the way it's been treated since then. So what does this all mean? The owner of the right-of-way or his successor in interest, and again, this is usually going to be railroads. So watch out if you got railroads crisscrossing your federal lease. The owner of the right-of-way is going to have a preferential right to lease or may assign the right to lease to another party, and notice will be provided to adjacent landowners. So if you're the owner of this right-of-way, you've got the first right of refusal to lease your right-of-way to somebody. Adjacent lessees have a right to submit a bid for compensatory royalty paid to the U.S. in lieu of issuing a lease to the right-of-way owner. So if you don't want to deal with the right-of-way owner, you can submit a bid for a compensatory royalty. However, if you do that, be aware that you have to provide notice to the owner of the right-of-way, and they're going to be able to come back and put in a bid to lease it themselves. The BLM is going to go with the offer that's most advantageous to the U.S. So because the BLM will not issue leases except to right-of-way and reservoir rights-of-way, they're possibly technically unable to lease prior right-of-ways, which gets a little weird. And the other problem is you may end up in a bidding war if you try to go for a compensatory royalty and then the owner of the right-of-way decides that they want to make their own offer. So the best practice is to approach the owner of the right-of-way and obtain an assignment of this pref right to lease, and then make your bid for compensatory royalty. Otherwise, you may end up with a possible trespass claim. You may end up in a bidding war. And then note that a compensatory royalty agreement is not a lease, and therefore you can't assign it. There's no record title or operating rights. So you have to file in the field offices sundry notice form 3160-5 to transfer the operatorship or the ownership. And one final note, a compensatory royalty may also refer to royalties paid in lieu of drilling an offset well. So again, this is just an area of federal leasing that not a lot of people know even exists or haven't encountered much. So in the event you ever do run across it, I wanted to put it in here so you could maybe come back and take a look at these slides and sort of refresh yourself on what you're dealing with and what the next steps may be. So now we're going to talk about lease segregation and maintenance, and what happens when your federal lease gets all hacked up into various pieces. There are several events that segregate a federal lease. The first one we talked about a few slides ago, and that's a record title assignment, which would be an assignment covering 100% in a portion of the lands, creates a base lease and a segregated lease. Another is if you're talking about a federal unit. Now, I'm not talking about communitization here, and we'll talk a little bit about the difference there later, but if you were talking about a unit agreement, and you only got a portion of your federal lease committed to the unit, the uncommitted portion is going to become a new lease. This does not occur, however, when a portion of a committed federal lease is eliminated from a unit. So if the unit boundaries shrink or are otherwise redrawn, then your lease is not going to be segregated. The segregated portion is again going to be issued a new lease number and treated as a distinct lease for maintenance purposes. So again, here's just sort of some examples of different types of segregation. So if you are talking about a segregation by assignment, if your lease is in the fixed term, now here's another just sort of distinction between federal and fee leases. The feds like to use their own language. Fixed term is what would normally be called the primary term in a normal lease. The extended term is going to be a secondary term, or as long thereafter as there's production paying quantities type stuff. And so in my first example here, the top illustration, the idea here is that there is no production. So you've got a segregation by assignment, but there hasn't yet been any production established. The lease is still in its fixed term. If you segregate the lease during the fixed term, the segregated portion is going to continue for the remainder of the fixed term, or 2 years, whichever is longer. The fixed term is usually 10 years in a federal lease. So if you're 9 years into your lease and there's a segregation, your segregated lease is going to get another 2 years because that's longer than the remaining 1 year in the lease. If you're in your extended term and the lease was issued before September 9th, 1960, I'm sorry, September 2nd, 1960, it's going to continue for the fixed term, or 2 years, whichever is longer. If it's after September 2nd, 1960, and the lease is segregated in the extended term by assignment, then it will remain extended by production on the base lease. So now we're going to talk about segregation by partial unitization within the fixed term. This stuff can make your head spin, and it gets rather complicated. So you just have to be sort of aware of what you're dealing with and the exact circumstances. So the general rule with unitization in the fixed term is that the lease stands on its own. So if we're in the fixed term and there's no production, then the lease is going to be effective for 2 years or the remainder of the fixed term, whichever is longer, very similar to segregation by assignment. If there is production on the non-unitized portion, it will not extend production as to the unitized portion. If there is unit production, it will not extend the non-unitized, non-producing portion, and the BLM generally will not approve unitization of specific formations, which would result in any kind of horizontal segregation. And again, we're talking about the fixed term here. General rule, the lease is going to stand on its own in the fixed term. Now, if you're within your extended or secondary term, it's going to change a little bit. Here, the segregated portion will be extended as long as the base lease is producing. So if you've got a producing base lease, it's put into a unit, there's a portion outside the unit, that segregated lease in the secondary term will remain held by production from the base lease. This is considered an exception to that general rule that the lease stands on its own. If you've got a base lease in a non-unitized segregated portion, the base lease is going to continue for the life of that non-unitized segregated portion. And if the unit production is obtained before cessation of the non-unitized portion, the unitized portion will continue for the life of the unit. I know you all got all that, and you understand it perfectly, and you're not going to have any questions about it. And if you do, feel free to shoot me an email. So let's see, how much time do I have left here? I got a few more minutes, and I'm going to try to buzz through a few additional things to be aware of with communitization versus unitization. Terminology, we all hate it, right? It causes all kinds of confusion. Words are mixed up, used interchangeably, and in no context is that more true than with federal leases. So when we're talking about pooling, we are not talking generally about federal leases exclusively. Now, you can have a federal lease that is part of a pooled unit or a compulsory pooled unit, though you can't compulsory pool the feds. But I'm actually going to talk about that tomorrow in an AAPL presentation about compulsory pooling across the country. But for purposes of what we're talking about today, pooling is not the term you want to use with federal leases. Pooling is when you combine two or more, usually fee leases, to meet minimum state spacing requirements. The idea is it prevents waste, protects correlative rights. Communitization is the federal word for pooling. It's pooling, but it's federal leases. So when we're talking about communitization, we're talking about federal, sometimes state pooling. But it is distinct from unitization, which is the unified development and operation of an entire geologic prospect or producing reservoir. So we're talking about three different things here. Unitization, the purpose is conservation, serving the public interest. The unit area is operated as a single entity, maybe more cost effective. You can use more common facilities. There's a model onshore unit agreement, not one for enhanced recovery units though. Allocation of production is usually made on an acreage basis. Exploratory units may be developed in stages, usually by a participating area surrounding a producing well. That part of the unit area, which is considered reasonably proven to be productive in paying quantities, is going to be what's in your participation area, or that's necessary for unit operations, into which production is allocated in the manner prescribed by the unit agreement. There's two types of unit operating agreements you might encounter. One for undivided interests, and that means that as participating areas expand or contract, you're basically going to have an undivided ownership as to the entire unit. It's not going to change. Under the 1994 JOA or unit operating agreement, which is divided interests, your working interest is going to be determined by your interest in a defined participating area. So it will vary from participating area to participating area. So, be aware of what UOA you are operating under. Communitization, leases may be voluntarily pooled and designation of pooling recorded in the county, but when federal leases are involved, you have to execute a communitization agreement. The BLM is going to require it, and you're going to have it in order to make sure that your leases are being maintained by production. Similar to pooling, there will be allocation on an acreage basis. There is a model form of federal communitization agreement that's generally followed. You can find it in the BLM manual. Defines the communitized area, depths or formations. It should be executed or ratified by each royalty, working interest, and override owner. Defines how production will be allocated. Supposedly there's a new streamlined approval process that helps ensure CAs are approved within 120 days. Love to hear your feedback as to whether that deadline is being met. Lease maintenance comparison. So unitization, operations, production anywhere within the unit are considered to be operations on each committed lease, very similar to communitization. So if you've got, operations going on somewhere, production, it's going to maintain all the leases in your unit or under your CA. For unitization, inclusion of only a portion of the lease, again, is going to create a segregation. Segregated portions outside the unit are extended for the remainder of the fixed term, or 2 years, whichever is longer. Refer back to my other slides for some of the nuances of that. Communitization, however, I mentioned this earlier, does not affect a lease segregation. So you're never going to be segregated under a CA. If the CA terminates, you're still going to get at least the remainder of the fixed term or 2 years to reestablish production or a new communitization agreement. So that's it, guys. Clearly, I just loved this Biden picture so much, I decided to put it here again. Just cracks me up. But if you've got any questions, feel free to reach out, shoot me an email. I love talking about this stuff. I love federal leasing. I love working with these. It can get, rather complex. We do a lot of work on federal lands in North Dakota and New Mexico. We've dealt with it in Louisiana, Wyoming, and we sort of have seen how it plays out across multiple states. So we have a
a very deep knowledge of some of the issues that are involved with federal leasing. So feel free to reach out if there's anything you want to bounce off me or the firm. In the meantime, thank you so much for joining us today. Some of you who are first-time joiners, you may receive a follow-up email from the firm, introducing ourselves and possibly wanting to meet and learn a little bit more about you. We love doing this. It's one of the ways that we expand our network and help similarly minded landmen, operators, attorneys meet each other. We're very big on networking and helping connect people. So again, we hope that you'll continue to join these webinars and that we can make some personal connections with some of you. And in the meantime, thank you so much for listening to me today. I really enjoy doing these, and they're a lot of fun to put together, and I particularly enjoy getting follow-up questions, so feel free to send them. Thanks and happy Halloween.